Good morning. That's a rowdy crowd out there. My name is Hillary Wandler, and I teach legal writing and legal analysis at the University of Montana School of Law. I'm privileged to welcome you to this session of the Montana Supreme Court and to introduce the case the court will hear argument on today, Barbara L. Maniaci versus Michelle Kulstad. So I have to remind you, though, that we are in a court of law today, so that's kind of unique for this forum, but you do have to remove your ball caps, and please do turn off all of your cell phones or turn them to silent. I see a lot of people grabbing cell phones right now, so make sure all of that is done before we proceed. So for a number of years, the Montana Supreme Court has made it a practice to hold some sessions outside of Helena. The court makes this special effort to assist high school students and college students and really the citizens of Montana to better understand our legal system and the role of judges and lawyers in that system. The court's efforts are very exciting because by coming here and making the process so accessible to us, we can better understand the impact of the court's actions on our society and on our daily lives. How many of you have never been to a Supreme Court hearing before? A lot of people. So today, for those of you who haven't, I'm just going to provide a little bit of background for you so it won't seem so much like the attorneys in the court are talking in Greek. First, I'll give an overview of the legal system and then spend some time discussing the major issues in this case so you understand those moving forward and hopefully understand a little bit of the language the attorneys and the court may be using. So first of all, in Montana, there are three major court systems: the federal court, the state court, and the tribal court. Each court system is essentially divided into two main categories: the trial court and appellate court. So the trial courts, with the help of juries, have the responsibility of hearing and resolving criminal and civil disputes. And the appellate courts are responsible for determining if any errors occurred during the trial court's resolution of those disputes. So taking a closer look at the federal system first, although we're not in the federal system today, the federal trial court system is made up of magistrate courts and district courts. And Montana currently has three active federal district court judges: Chief Judge Richard Siebel in Billings, Judge Donald Malloy here in Missoula, and Judge Sam Haddon in Great Falls. Judges Jack Shandstrom and Charles Level are also Montana federal district court judges, and they are on senior status. And then we have three federal magistrates as well: Judge Lynch here in Missoula, Judge Strong in Great Falls, and Judge Osby in Billings. The federal appellate courts are the United States Court of Appeals and the United States Supreme Court. The federal appellate courts hear appeals from the federal trial courts. Montana is part of the Ninth Circuit Court of Appeals. A lot of you are probably familiar with that name, and we are part of that along with California, Hawaii, Washington, Oregon, Idaho, Arizona, Nevada, Guam, and the Northern Mariana Islands. We have a Ninth Circuit Court of Appeals judge sitting in Montana, actually in Billings, Montana, and that's Judge Sidney Thomas. The United States Supreme Court is the ultimate appellate court in the country, and that court hears appeals from both the federal level of courts and also from state Supreme Courts. So moving into the Montana State Court system, which is where we are today, the Montana State Court system also includes trial courts and an appellate court. The trial courts in Montana include courts of limited jurisdiction, like the Justice of the Peace and city courts and the municipal courts and small claims court, and a lot of you may be familiar with those. They deal with traffic citations, misdemeanor crimes, and smaller civil crimes. If you've ever paid a traffic ticket, you've probably had contact with those courts. I won't ask for a show of hands on that one. In addition to those courts of limited jurisdiction, there are state district courts, and that's what court decided the case we're hearing today. The case we hear today arose out of the 4th Judicial District Court, which includes both the Missoula County and Mineral County. The 4th Judicial District has 4 judges, and District Court Judge McLean decided the case that we are hearing today. So unlike the federal system, Montana does not have kind of an intermediate level of appellate court. In fact, in Montana, all the appeals go directly to the Montana Supreme Court. 7 justices make up the Supreme Court, and those include Chief Justice Mike McGrath, Justice James C. Nelson, Justice W. William Leapart, Justice Patricia O'Brien Cotter, Justice James A. Rice, Justice John Warner, and Justice Brian Morris. In addition to the federal and state court systems in Montana, we also have the tribal court system. The tribal court systems vary in how they're organized, so some of them closely mirror the state and federal court organization, but others go with a more traditional tribal approach. So now let's move to the case we're going to hear about today, Maniaci versus Kulstad. And so first I'll give you a little bit of background. Barbara Maniaci and Michelle Kulstad lived together for 10 years, starting in 1996. During that time, Miss Maniaci legally adopted 2 children, the first in 2001 and the second in 2004. Miss Maniaci and Miss Kulstad separated in 2006, and then a year later, Miss Kulstad filed a petition against Miss Maniaci in the 4th Judicial District Court, as I was saying, here in Missoula. In her petition, Ms. Kulstad sought a parental interest with respect to the 2 children who were brought into the home during the time the couple lived together. Ms. Kulstad also requested that the court order Ms. Maniaci to pay her back for some money she had spent while the couple lived together. In her petition, Ms. Kulstad sought a parental interest under a Montana statute that you'll probably hear a lot about today, and that is Section 40-4-228. That statute allows a court to award a parental interest to a person other than the child's natural parent. So here's another thing you'll hear a lot about today, which is natural parent. You'll probably hear that term. And you should understand that under Montana law, an adoptive parent is considered a natural parent, so that means the statute we're talking about, 40-4-228, applies to both adoptive parents and birth parents. For the court to award her a parental interest in the children under Section 40-4-228, Ms. Kulstad had to prove 3 things by clear and convincing evidence. First, that Ms. Maniaci, the legal natural parent, engaged in conduct contrary to her parent-child relationship with the 2 children. Second, that she, Ms. Kulstad, though not legally the natural parent because she wasn't the legal adoptive parent, had established a parent-child relationship with the 2 children. And then third, that it is in the children's best interest for their relationship with Ms. Kulstad to continue. Section 40-4-228 also explains that when a parent voluntarily permits a child to remain continuously in the care of others for a significant period of time so that the others stand in loco parentis to the child, then the parent has engaged in conduct that is contrary to the parent-child relationship. So this is another phrase that you'll probably hear today, in loco parentis. This literally means in the place of the parent. Judge McLean of the 4th Judicial District Court found that even though Montana law prohibits same-sex couples from adopting, the women had intended to parent the children equally. And Ms. Maniaci consented to and fostered a parent-like relationship between Ms. Kulstad and the 2 children. Judge McLean heard testimony from some experts as well, and so you'll probably hear something about the content of their testimony in front of Judge McLean. Judge McLean found that the experts had said the children suffered from attachment disorders, that they had developed a strong attachment to both women, and that their capacity for future healthy relationships would be jeopardized if another significant relationship was severed. Experts also testified that children of same-sex couples experience no psychological disadvantage. So that's kind of the baseline of what the experts testified to at the trial. Judge McLean awarded Ms. Kulstad a parental interest in the children with joint decision-making authority and regular visitation. He also found that Ms. Kulstad had acted as what is called a de facto parent, and that's another term you'll probably hear today. De facto parent literally means parent in fact. And so he concluded that because Ms. Kulstad resided with the children, with Ms. Maniaci's consent, performed caretaking functions equal to Ms. Maniaci's, and was a part of the children's daily routine, she had acted as a de facto parent, or in fact as a parent. He concluded on that basis that she had a right to seek a parental interest. Judge McLean also found that Ms. Kulstad had taken on debt to support the family and help Ms. Maniaci grow her business, and that Ms. Maniaci had promised to repay Ms. Kulstad if they separated. And on that basis, Judge McLean determined that Ms. Maniaci was required to repay Ms. Kulstad. Ms. Maniaci has appealed the district court's decision to the Montana Supreme Court, which brings us to the hearing today. And so in this appeal, the Montana Supreme Court will review Judge McLean's decision and will decide essentially three major issues. First, whether Section 40-4-228 is constitutional. Second, whether Ms. Kulstad presented enough evidence to support Judge McLean's decision to grant her a parental interest under that statute. And then finally, whether Ms. Kulstad proved that she was entitled to an award of Ms. Maniaci's property, or to that money or damages award that Judge McLean gave. So first, as to the constitutionality issue, some background on that. Montana law recognizes that people under the age of 18 have fundamental constitutional rights. For those of you who are under the age of 18 in this room, this might be news to you, but you do have fundamental constitutional rights. And that parents as well have a fundamental constitutional right to autonomy in child-rearing decisions. And the legislature has said that some situations require the court to balance those two interests, those two constitutional rights, between the child's constitutional interests and the parent's constitutional interests. So on this first issue, Ms. Maniaci argues that Section 40-4-228 is unconstitutional because it doesn't strike the right balance between those two constitutional interests, between the parent's rights and the children's rights. She argues it allows the court to abrogate or limit the legal natural parent's constitutional rights without showing that that parent is unfit to parent the children in some way. And Ms. Maniaci says that to show a parent is unfit, you would have to demonstrate that the parent has abused or neglected the child or has dependency issues. Ms. Maniaci argues that as an adoptive parent who has adequately cared for her children, she is a fit natural parent under Montana law. She points to previous cases decided by this court, the Montana Supreme Court, where the court has said it does not permit destruction of a natural parent's fundamental right to the custody of his or her child based on a subjective determination of the child's best interest, unless there's a showing of abuse or neglect. For instance, Ms. Maniaci points to one case in particular you'll probably hear about today called JNP, where the Montana Supreme Court explained that allowing a judge to use a subjective best interests of the child standard to trump the natural parent's constitutional rights could result in some dangerous conclusions. For instance, that a child should be raised in an affluent family as opposed to an impoverished family, or raised by extremely intelligent parents as opposed to parents with average intelligence, or in a conventional lifestyle as opposed to an unconventional lifestyle. So on the other hand, Ms. Kulstad argues that Section 40-4-228 is constitutional because it does adequately balance the constitutional rights of the parent with the constitutional rights of the child. The reason she says this is because the statute requires, before granting a non-parent a parental interest, that the court find conduct inconsistent with a parent-child relationship, and also that the non-parent had established a child-parent relationship with the children. And so by having those standards in place, it protects both interests and adequately balances them. Ms. Kulstad also argues she's not really a non-parent under the law because she and Ms. Maniaci have in fact been the children's co-parents from the first moment the children were brought into the home. She argues that the purely legal distinction that Ms. Maniaci was the legal adoptive parent due to Montana law prohibiting same-sex adoption is really the only thing that makes them different than a married couple who had adopted 2 children. Ms. Kulstad argues that because Ms. Maniaci encouraged a parent-like relationship between her and the children from the beginning, the constitutional rights of the children should be protected from, or to be protected from emotional harm from severing the relationship with one of the 2 of them, should be put above Ms. Maniaci's constitutional rights as the legally adoptive parent. So now moving on to the second issue, which is whether Ms. Kulstad proved that she should have a parental interest under that statute. Ms. Maniaci argues that if that statute, section 40-4-228, is constitutional, then Ms. Kulstad failed to present enough evidence to prove those 3 factors we were talking about under the statute that she needed to prove to be entitled to a parental interest. Ms. Maniaci argues that part of section 40-4-228 that says a parent contradicts the parent-child relationship when she permits a non-parent to stand in loco parentis to the child means that a parent must actually leave her child exclusively with another person for a significant period of time, or in fact abandon her child to another person for a significant period of time before the court can say that parent has acted in contradiction to the parent-child relationship. In other words, Ms. Maniaci argues that because she never actually left the children with Ms. Kulstad, the 2 of them were always in the home, Ms. Kulstad can't prove that she allowed her to stand in loco parentis or in the place of the parent with respect to these 2 children. Ms. Maniaci also argues that even if Ms. Kulstad somehow stood in loco parentis, or in the place of the parent with respect to the children, Ms. Kulstad cannot prove that she established a parent-child relationship with these children. So Montana law defines this child-parent or parent-child relationship. It's seen both ways in the briefs, although in the statute it's called a child-parent relationship, as a relationship that developed before the person filed an action seeking a parental interest, and in which a person provides for the child's physical needs, like food or shelter or clothing, and psychological needs, like daily interaction and companionship. According to Ms. Maniaci, the expert testimony regarding Ms. Kulstad's relationship with the children really focused on the time right before she filed this petition and the time period after she filed the petition. And Ms. Maniaci says when you look at the other evidence, the testimony of the people who knew the couples, Ms. Kulstad did not parent the child or the children as her own. So on the other hand, Ms. Kulstad argues that the focus should be on whether Ms. Maniaci contradicted her exclusive parental interest. She argues that Ms. Maniaci did contradict her child-parent relationship by co-parenting with Ms. Kulstad from the moment the children came into the home and representing to other people that she was co-parenting with Ms. Kulstad. Ms. Kulstad also says that Ms. Maniaci contradicted the child-parent relationship by allowing Ms. Kulstad to care for the children on the daily basis as a parent. According to Ms. Kulstad, section 40-4-228 may be interpreted to say that a parent acts contrary to her exclusive parental interest by consenting to and encouraging the development of a parent-child relationship between another person and her children. Ms. Kulstad argues that she acted in loco parentis, or in the place of the parent, in this case, by co-parenting the children from the moment they came into the home. So in addition, Ms. Kulstad argues that Judge McLean correctly determined that she had established this parent-like relationship, or was a de facto parent, based on her daily presence in the home and the evidence of her daily care for the children. She points to expert testimony that she had developed close parental ties with the children, and to testimony of friends and teachers and others who knew the couple supporting her, showing that the children understood her to be a part of the family. Ms. Kulstad argues that the evidence supports Judge McLean's conclusion that she became a de facto parent. So remember that term, a parent in fact. And that Ms. Maniaci had fostered that parent-like relationship with the children while they were together. Ms. Kulstad argues that Judge McLean properly considered this principle. It's called an equitable principle. In other words, that he considered the unfairness of allowing Ms. Maniaci to sever Ms. Kulstad's relationship with the children after encouraging a parent-like relationship between Ms. Kulstad and the children. So then moving on to the last kind of major issue the court is going to hear about today, and that's the property award. Ms. Maniaci argues that Ms. Kulstad is not entitled to property division. You'll probably hear the term in this part of the argument, unjust enrichment. This means essentially that it would be unfair if Ms. Maniaci did not pay Ms. Kulstad back for the money Ms. Kulstad spent while the two were together. And so one way of describing this is if Ms. Kulstad paid for things while they were together, expecting to be paid back, and Ms. Maniaci hasn't paid her back. And then also that Ms. Maniaci benefited from the situation while Ms. Kulstad suffered from it, the court can say that Ms. Maniaci was unjustly enriched and has to give some of that money back to Ms. Kulstad. Ms. Maniaci argues that Ms. Kulstad cannot prove that she suffered any unjust result from the mutual expenditures during the time they lived together, or that Ms. Maniaci took advantage of her to her detriment in any way. Ms. Maniaci also argues that Ms. Kulstad living with her rent-free and causing damage to the property means that Ms. Maniaci experienced no benefit from the expenditures during the time they lived together. On the other hand, Ms. Kulstad argues that Judge McLean's decision that Ms. Maniaci was unjustly enriched is supported by several things. First, the evidence that she paid to improve the home during the time they lived together. Second, the evidence that she was the main support for the two for about 5 years before Ms. Maniaci started to further develop her business. And then last, that Ms. Maniaci agreed to divide the property with Ms. Kulstad if they separated. So in a moment, we're going to hear the arguments from the parties. And so I'm going to explain a little bit about how the court is going to proceed. Both the parties have filed written briefs setting forth their positions. The judges and their law clerks have had time to read those briefs and internalize them and have some specific concerns that they want to hit on today. In this case, several other briefs were also filed by advocacy groups who don't necessarily represent either side, but the court allowed them to file briefs on specific points of law. None of those advocacy groups will be speaking today, though. Ms. Maniaci, who is called the appellant on appeal because she's appealing the district court's decision, is represented by Linda St. Peter, Brian Raum, and Austin Nimitz. Austin Nimitz will be presenting the argument today and present that case first and set forth the reasons why they think the district court's decision should be reversed. Ms. Kulstad, who prevailed in the court below and is called the appellee, is represented by Susan Ridgway, Elizabeth Griffin, and Kevin Lewis. And today, Elizabeth Griffin will be presenting Ms. Kulstad's argument in response to Ms. Maniaci's argument. So in oral argument, when the attorneys are presenting to the court, The justices can interrupt them at any time and ask a question. Like I was saying, the justices are very familiar with this case by now and have specific concerns, and so will likely interrupt and ask questions about those concerns throughout the argument. And the attorney's job is to satisfy the judges or the justices' concerns so that both parties' positions are really fully understood by the time the argument is over. According to the rules of appellate procedure, the appellant, Ms. Maniaci, will have a total of 40 minutes to argue. Then the appellee, Ms. Kulstad, will have 30 minutes. The appellant has the option of reserving some time for the very end as a rebuttal argument. Today we have in the courtroom Deputy Clerk of Court Rex Ring, sitting over here at this table. He's going to call court, and he will also keep time for counsel. After the argument is over, the justices meet in conference and discuss the case, and one justice typically is assigned to present the written opinion of the court, and a draft of that decision is circulated to all the justices, at which point any one of them can disagree with the way that opinion is written. And sometimes individual justices write a separate opinion saying if they agree on other grounds or actually disagree with the majority decision. The final decision of the majority, together with any concurring or dissenting opinions, is filed by the court with the clerk of court and printed as part of an official set of the Montana Supreme Court's decisions that's called the Montana Reports. I would like to again welcome you and thank you for taking the time to come to this special session of the Montana Supreme Court. And in a few short minutes, after we arrange a few things on the stage, you will hear the argument of Maniaci versus Kulstad. Thank you.
Good morning. I want to begin by thanking the School of Law at the University of Montana, particularly Dean Eck, for providing us this opportunity to come to the university for this argument this morning. And with that, we will proceed. Counsel ready? Proceed.
May it please the court. Mr. Chief Justice, members of the court, good morning. My name is Austin Nimmix, along with co-counsel Linda St. Peter and Brian Rahm. It is our privilege to represent Dr. Barbara Maniaci. Dr. Maniaci is a fit natural parent under the United States Constitution and that of Montana. That is the foremost and most significant fact in this case, because attached to her status as a fit natural parent are a panoply of rights that are implicit within the concept of ordered liberty in this country. Those panoply of rights include the right of her as a fit natural parent to control the future and upbringing of her own children. This court has repeatedly recognized that when dealing with a fit natural parent, there is a bright line drawn in the sand. That bright line is that the state or the government is not going to get away from child protection and into child rearing. It is going to uphold the presumption that a fit natural parent acts in the best interest of her children at all times. It is not going to supplant its judgment for that of a fit natural parent. The bright line is crossed only in this state when the grounds exist for what is called a Title 41 proceeding, where the natural parent at issue subjects their children to harm or abandonment. And this court has upheld that standard for a very long time. A Title 41 proceeding, as this court has commented on, is one that is usually instituted by the county attorney or an attorney general or another authority that calls into question the fitness of a natural parent at issue. In this particular case, a significant fact is that the fitness of Dr. Maniaci has never been called into question. It was not pled by the plaintiff in this case. It was not called into question by the court. And there are no facts whatsoever to support any notion that she is anything other than a fit natural parent. The constitutional significance of that fact in and of itself is grave, because beyond that, neither this court nor any district court of this state has the right to interfere with her ability as a fit natural parent to determine who her children do and do not spend time with.
Counsel, what deference or weight should we accord to the constitutional right of children under Article 2, Section 15? Does that enter into your analysis at all?
It does, Justice Cotter, and this court spoke to that very question in the ARA case, which is a custody case from 1996, talking about what the constitutional rights of the children are. And what those constitutional rights are specifically is the right to know and continue the relationship with their natural parent. That's the specific language that this court used. And it did that quoting Stanley versus Illinois, which is the 1977 case from the United States Supreme Court. That is a very significant point, and it ties in, as this court explained in ARA, to the fundamental right of the fit natural parent, that there's this relationship there between the natural parent and the child, and that when we're upholding the rights of the fit natural parent, we are also in concert upholding the fundamental rights of the child as well to know their natural parent.
But in ARA, weren't we talking about the destruction of the relationship between the natural parent and the child, instead of, as here, talking about giving an additional person parental rights instead of destroying the rights of Dr. Maniaci? Isn't that a distinction?
Respectfully, Justice Carter, no, I don't think so, because in ARA the question was whether or not a third party was going to acquire custody of the girl at issue over the fit natural father. And so in weighing the balances, of that case and looking at it with all the facts in that case seem to indicate that the stepfather at issue was actually a better parent. And the court made factual findings that there was, I think, a better educational situation, and the daughter had grown attached to her half-brother, and that the stepfather had really been the only father figure in her life from the age of 2 to 5 when her mother died in this tragic plane accident. That's significant, yet this court said, no, the fundamental rights of the child at issue are to know her natural parent, because to go beyond the natural parent is to go down that slippery slope.
Well, didn't we recognize de facto parentage and psychological parentage in KEV? And in fact, in that case, we denied the biological father the right to obtain DNA tests to prove his actual biological parentage.
Well, Justice Nelson, in recognizing those doctrines, I think this court in KEV recognized them in passing. The statement where it's used, this court uses the de facto parenting statement is kind of listening what all the doctrines are. But secondly, I think most importantly, KEV is a parentage case. And as this court in the Girard case outlines, there are several avenues that the legislature has developed through where a third party can acquire a right in somebody else's children. Parentage is one of them, and the only issue in KEV is whether or not the natural father was stopped from a parentage standpoint. And there's precedent when we get into parentage that goes well beyond the issues in this case. For example, go ahead.
Well, isn't 40-4-228 such a legislative path that our legislature has taken to allow third parties to acquire parentage rights?
Justice Nelson, it is. It is a legislative path. It's one of many. And so the legislature has these paths. There's guardianship, there's parentage, there's adoption, there's grandparents' rights, and then there's custody, which is 228 and 211 in concert together in this particular case. But just because the legislature has created a path does not mean that the legislature can go outside the clear constitutional lines that this court has drawn time after time after time. The legislature has the right to try to delineate standing and the adjudication of those rights so long as it doesn't cross that bright line. And so that's why in JNP, for example, this court struck down Section 211 because the legislature did not stay within those constitutional lines. In ARA, when this court struck down Section 221, it's because the legislature did not stay within those clear constitutional lines. And so you look at Section 228, and it does not stay within those clear constitutional lines. Clearly, when in subsection 5, it states that a court need not find that a parent is unfit before parsing out parental rights to third parties. I'm paraphrasing the subsection, but I'm sure you understand what I'm referring to. That is clearly unconstitutional under the clear precedent of this court and the precedent of the United States court, which this court has clung to throughout the last several decades of adjudicating the rights of fit natural parents in this state. 228 is also unconstitutional in many other regards because it fails in any regard whatsoever to even remotely suggest that the fitness of a natural parent at issue must be adjudicated properly before we can start crossing the thresholds. And that question has come up in multiple contexts where this court has acknowledged that these avenues of third-party rights create standing, perhaps, in parties. But before you can get to the point of actually giving these rights to third parties, you still have to have the termination of the parental rights of the fit natural parent at issue before you.
Aren't you assuming that there can only be one parent?
I'm assuming, Justice Liebhart, that I'm operating within the framework of Montana law. And Montana law has a couple of avenues for adjudicating or determining who can be natural parents at the outset. And one of those is, for example, the adoption statute. The adoption statute says that a single person can adopt or a married mother and father can adopt. That's one of the ways you can become a natural parent. That's significant in this case because we have the natural parent relationship created through adoption. Obviously, you can also become a natural parent through natural childbirth. And so when you look at that, and the adoption statute says, all right, here are the parameters of who can be a natural parent, it's quite clear that you can only have, in this instance, one natural parent. And when you do the adoption, obviously by nature and virtue of the adoption, the parental rights of the former biological parents are terminated through the proceeding. So coming into the courtroom, there is by definition, and as a matter of law, only one natural parent. And that can't be changed. The only way that that could be changed is if the parental rights of the natural parent at issue are terminated or suspended, and then the parental rights are established with a third party.
You can't supplement that relationship by bringing another parent into the picture?
You can, it's possible to do that, Justice Liebhart, but again, there has to be an adjudication. There has to be consent. I mean, either the natural parent has to cross that bright line and start abusing, neglecting, harming their children and have their rights terminated through a Title 41 proceeding, or the natural parent has to give up her parental rights and through another adoption proceeding or something along those lines. And those are pretty much the means by which that can happen. And there's a very high bar that this court has recognized for the relinquishment of parental rights. You know, just circumstances in and of themselves don't lead to the relinquishment of parental rights, because
We're not talking about relinquishment of parental rights in this case.
I agree, Chief Justice McGrath, because I don't think there are any facts that even get to the level that it can be suggested in this case that there was a relinquishment of the parental rights of Dr. Maniaci. This court makes clear, for example, I mean, the argument that is being put forth by Ms. Kulstad here is because she was in the home with Dr. Maniaci and the children, ergo there's this voluntary relinquishment or waiver of parental rights. And yet this court in the KM case from 1996, I believe was the year, dealt with a situation where the mother and the children were in the home with the grandparents, and the grandparents were arguing specifically, no, we were in the home with them and we were taking care of the child along with the mother, and this court said clearly that she never relinquished custody to anyone. Just because the children, the mother, and the grandparents lived in the same household for some months cannot serve to vest the grandparents with any right to custody of the children, any more than sharing a household with any person, be it a boyfriend, a relative, or roommate, will somehow create in that person a right to seek custody of the child of another. I think that's a very clear statement that just because you're under the same roof doesn't necessarily mean that you either A, voluntarily relinquish your parental rights, or that B, that parental rights are created necessarily in a third party.
But don't those cases speak to the parent that's perhaps relinquishing the rights, but not speak to the children? In other words, not only the parent that is there, such as Ms. Kulstad in this case, or the purported parent, but also what the children have to do with this. Don't our cases seem to ignore that?
I don't think so, Justice Warner, and I think it's wrapped up into the principle that this court recognized in ARA, is that the fundamental rights of the children and the fundamental rights of the natural parent are not independent concepts. They're actually directly connected because we recognize that connection of the natural parenthood. And so when we're upholding the rights of the fit natural parent, we're simultaneously upholding the fundamental rights of the children as well.
Could it not be argued, and how would you answer the argument, that we are limiting the fundamental rights of the child rather than upholding them?
I think
That the child's rights are cut off at fitness. Isn't that, in essence, what you're arguing?
Well, I think the child's rights are clearly defined. But if I understand what you're asking, if you cross that line, exactly where, I don't know where the definition would lay, and then that's where the state and the government starts getting into the difference between protecting society and children and rearing society and children, and that's the policy.
Protecting society and children from what?
Well, I mean, that's a fair question, and I think when you look at Title 41, what is the standard in Title 41? Abuse, harm, neglect. That's where this court draws the line in saying, before we invade the province of a fit natural parent, we have to believe and see through a proper proceeding that a child is being subjected to abuse, harm, or neglect.
Well, is there some evidence in this case that Ms. Kulstad was abusing and harming, neglecting the children in some way?
No, there has been evidence presented. There was no factual findings by the court in that regard, but I think that the question here is whether the district court should not defer to the desires and wishes of the fit natural parent who has the fundamental right to control the future of her children unless she, the fit natural parent, is subjecting her children to harm, abuse, or neglect. It's not just, because if the standard is flipped on whether the third party is abusing, harm, or neglecting, then that crosses the bright line and the court starts getting into supplanting its own subjective judgment on what's in the best interest for the children for that of the fit natural parent who is entitled to make those decisions. As this court stated clearly in J&P, just because the district court feels like it can make a better decision doesn't mean it's entitled to make that better decision, because then we turn our district courts into child rearers, and you have various standards throughout the entire state. And
Well, if you look at Section 40-4-212, that lists a whole bunch of child rearing standards that courts have to apply all the time. So I don't quite follow why courts should be bound to follow those standards in dissolution cases or custody cases and not in a case such as this.
Justice Nelson, if I recall correctly, 212 is the best interest statute that kind of defines parameters for what defines best interest of the child. Mm-hmm. And to answer your question, the reason that's used is because in, for example, a custody case or a divorce case, you're starting with generally two natural parents to begin with. The parents at issue stand on equal footing from a constitutional standpoint, and so not one of their rights is given deference over the other. And so in that instance, the district court is entitled to delve into the best interest standard because it has to make a decision there as to who's going to be the primary custodian. Here, we're not dealing with that. We're dealing with a situation where one of the parties clearly stands on higher legal ground, without question, than the other. And so if the court adopts a best interest standard, it's not giving the proper constitutional weight to the party who stands on high legal ground. The best interest standard should never be applied in this particular case, and the district court was in error to do so because it failed to give any weight whatsoever, much less special weight, as the United States Supreme Court talks about in the Troxel case, to the deference and preference of the fit natural parent. And again, not to beat a dead horse, but this court has made clear multiple times that unless there is a successful Title 41 proceeding that calls into question or terminates the rights of the fit natural parent because they are abusing, neglecting, or abandoning their kids.
Let's assume for a moment that the court doesn't agree with your constitutional argument about 44-228. How should we interpret that statute in this case? I assume you're not arguing that the courts then have to make a finding of that the parent's unfit. The statute specifically says that the court does not have to do that.
Chief Justice McGrath, assuming that 228 is constitutional for the purposes of argument, the plaintiff's case still fails here, and for many reasons. Number one, there's a high evidentiary burden, which is clear and convincing evidence, which we don't feel she met. But I think most importantly, there's no way under Montana law that she can meet the required statutory standard of demonstrating that she was in loco parentis. And the definition of that doctrine is very important, because the way that
So
she's...
the district court erred when it made that determination?
The district court erred in not even making that determination, Chief Justice McGrath. The district court never used the word in loco parentis once in its opinion, and it used it only in quoting KEV, which recognizes the different doctrines. That's it. The district court never even made a factual finding of in loco parentis, which is absolutely required. I mean, that's clear error on its face. The definition of in loco parentis that this court is being asked to adopt by the plaintiff not only runs contrary to Montana law, it runs contrary to the plain definition of what that doctrine really is. And it means in the place of the parent, substituted in the place of the parent. As the facts of this case are absolutely clear, Dr. Maniaci was never absent from the situation at all. She was never missing. From the moment she adopted the kids, she was the primary caretaker. She was always there. She was always in the home. She was always in control.
Do you interpret the statute to require that she be missing? It doesn't say that's a requirement in the statute. It's not exclusive of the other parent.
Chief Justice McGrath, I interpret the statute when the legislature specifically chose to use the doctrine of in loco parentis in defining the parameters of how a third party could acquire the rights. It chose that doctrine over any other doctrine. Knowing that you have the de facto parenting doctrine out there and equitable estoppel and the other doctrines that this court references in passing in the KEV case, it specifically chose that doctrine.
But back to Justice Leapart's question, there can be more than one parent, can there not?
In this case, as a matter of law, there can only be one natural parent because we had a single parent adoption. And when you look at the statutory parameters of who can become a natural parent and how they can become, that's the only possible avenue. And it depends on how you define parent. And I use the word natural parent, again, because that distinction and that title that's bestowed upon Dr. Maniaci by virtue of her single parent adoption puts her up on a constitutional pedestal that requires a Title 41 proceeding to knock her off. And that's significant. And you can use the word parent loosely in talking about parental figures and people who may be authority figures over children. But you can't just supplant the requirement of who can become a natural parent by circumstance.
Counsel? Go ahead, Bill.
The issue isn't whether the natural parent is going to be replaced, is it? Isn't the issue whether the parent-child relationship is going to be supplemented?
Well, that's one of the requirements of the statute, Justice Leapart. I mean, there's multiple requirements. And so even if you assume a parent-child relationship, that parent who has established the parent-child relationship has to be in loco parentis. And I think the statutory intent is clear. The legislature is saying that we're not going to give third parties custody unless the natural parent is out of the picture. And I think
But again, your assumption is that there is only, that there can only be one natural parent or one parent.
I don't think it's an assumption. I think I'm operating and making that argument within the clear, bright lines of Montana law, because Montana law provides specific lines through which one can become a natural parent. And I don't think it's the duty or province of this court to say, no, you can become a natural parent through all these other options, when the legislature has clearly spoken to this arena and said, here are the avenues by which you can become a parent. You can become by adoption, etc. And so looking at those avenues, none of those apply to this situation with the plaintiff at all.
Counsel, I'd like you to step away from the statute for a minute. One of the assertions made by the district court and is argued by Ms. Kulstad is that Ms. Maniaci should be equitably estopped from denying parental rights to Ms. Kulstad because she, in fact, is the one, according to the court's findings, that invited Ms. Kulstad into the relationship as a co-parent. Could you address the application of equitable estoppel?
Yes, Justice Cotter. The equitable estoppel doctrine upon which they're relying was introduced in the KEV case, which I think is in 1994. And this is the case we discussed a moment ago. That is strictly a parentage case. And there's precedent for the notion of equitable estoppel in strictly a parentage situation. And I stress that because this is not a custody case. KEV is not a Section 211 or Section 228 case. This is a parentage case. So this is one of those avenues of becoming a natural parent that really isn't applicable here because the parentage statute is very strict. But there's a policy under this state and in many states that when a child is born within a marriage, there is presumed that the husband and wife are the natural parents. And that may not always be the case. It's a rebuttable presumption. But we try to uphold that presumption. And so my point being is that there's legal precedent for equitable estoppel in the parentage realm strictly because of the historical precedent that's been upheld. But I don't think the parentage law or the parentage statute is applicable here. In any case that deals with the parentage circumstance should be applied. Matter of fact, the parentage claim that was actually filed by Ms. Kulstad was ultimately dismissed by the district court, and it wasn't even appealed. So, I mean, we're not in the realm of parentage here with respect. And there's no other case that they bring to the table to support this proposition. So equitable estoppel in the parentage realm, I can see and understand that. I don't think it has any applicability here to custody. We're talking about a completely different set of circumstances, different statutory scheme, and a different standard. When this court has repeatedly said Title 41.
So the fact that Ms. Maniaci invited Ms. Kulstad into the relationship in a co-parenting stance is not something we should take into account?
Absolutely not. And the reason I say that, Justice Cotter, is not just because the KM case, which I quoted a moment ago, where you have the mom and the child inside the home of the grandparents where the grandparents are acting in a parental figure. But you have case after case after case where you have that similar circumstance where another party, a third party, is invited into the home, invited to take on a co-parenting role. And time after time after time, this court has said that is not determinative of the ultimate outcome. Until that natural parent's rights are terminated, then this co-parent doesn't have standing. And a good example of that is the Miller case. And this is a case where you have a mother who had a son and then married a man. The son was 4 years old, brought him into the home, had 2 more children with him, and this man was her son's parent for about 10 years before they got divorced. He was the only father the son had ever known. There was clearly a co-parenting relationship. There was a father-son bond that was developed there. And when the divorce happened, the district court even made factual findings that the children were in grave danger if they stayed with the mom. The mom was, for some reason, a really bad parent. And this court made it clear and held the line. Until her rights are terminated through a Title 41 proceeding, we don't care how bad of a mom she is. That is a necessary prerequisite. Matter of fact, the language this court used in the Miller case is significant. It is a foundation. It is a foundation for the usurpation of parental rights. There is not that foundation in this case. In the ARA case, the language this court used was that it was a jurisdictional prerequisite. And I think that is very, very clear language from this court as to what must happen before you can give parental rights to a third party under 211 or 228.
But don't you argue then, back to your constitutional argument, hasn't the legislature attempted, unsuccessfully from your standpoint, to change the Miller case by providing an addition to Title 41 in Section 228 as we have it today?
I think the legislature could maybe alter the parameters of Title 41, but what the legislature cannot do is alter the clear constitutional parameters or guidelines.
Back to the Constitution.
Absolutely.
Yeah.
And even though the statutory schemes about which we're talking about have evolved and changed a little bit over time, when this court has spoken, for example, in the Miller case, the KM case, the JMP case, the speak that this court has made with regard to those things have been constitutional principles to be upheld. Unchanging facts that changing statutory schemes don't change at all. These constitutional principles remain. And as long as the legislature is within those lines, they're okay. But here in 228, they clearly stepped outside of those.
Right, and they could step outside by amending Title 41 to provide that a definition of fitness is loosened substantially. You could be held to be unfit in the province of the legislature, should they so decide. A lot easier than you can now. That would be within the province of the legislature, would it not?
I don't agree with that, Justice Warner, and I'll tell you why. I think it's actually, in some respects, a coincidence, so to speak, that Title 41 matches the constitutional standard that's required. And so it's been easy for this court to look at Title 41 and say, that matches the constitutional standard. But the idea of abuse, harm, and neglect and abandonment didn't originate in Title 41. That's originated in the precedent of the United States Supreme Court, which this court has adopted. So if the legislature did a complete overhaul on Title 41 and made it a lot easier, I don't think that changes the standard that this court has delineated. It just happens to coincide with Title 41. If they loosen it up, I feel that under the precedent of this court will hold the line and abandon its marriage to Title 41 and still hold a very clear constitutional line. I believe that's clear under the precedent.
I take it, counsel, from your argument that if the roles were reversed in this case, if Ms. Kulstad had adopted the children and was now trying to exclude Dr. Maniaci from that relationship, you would be here supporting her as well?
If the roles were reversed and Ms. Kulstad was the fit natural parent?
Was the adoptive parent, yes.
Was the adoptive parent? Absolutely. I mean, the fundamental tenet, if I understand your question, that we're arguing for here is the rights of a fit natural parent. And unless you have that title bestowed upon you, that your rights are substantially less and substantially different. So if the roles are reversed and Ms. Kulstad is the fit natural parent at issue, absolutely.
Well, the reason I asked the question is there was a lot of evidence before the district court regarding the relevance of sexual orientation on parental rights and abilities and so forth. It seems to me that got kind of injected into this case also.
It was injected into the case, but it wasn't injected by us. We never raised or pled in anything that the sexual orientation of the parties is relevant. Matter of fact, one of the opening statements we have in our brief is that if the plaintiff here was a man, we would still be here, we would still be making the exact same arguments, and the issues before the court would be the exact same issues, just like the step-parent cases in Miller and ARA. The sex of the parties is irrelevant, and it doesn't matter. The plaintiff brought to trial an expert whose only expertise was testifying on the issues of same-sex parenting. And as we made clear in the briefing, we objected to that. We felt we were ambushed by that, and it was unfairly, the trial was unfairly derailed on what the fundamental issues were. And the court allowed us, because we had an expert there already who had some knowledge about this, to put her on and tacitly try to rebut some of that testimony just so that the record wasn't naked. But that's not an issue that we brought up. Our expert,
Dr. Hansen? Is that
Dr. Hansen, that's correct, Justice Nelson. We brought Dr. Hansen strictly to testify about the ethics or lack thereof of the court-appointed expert. And I think if you read the transcript, the testimony is pretty clear. That was the only province of her testimony. But after we were ambushed with the testimony of Dr. Dixon, we let Dr. Hansen do what I would call a very tacit response in that regard. But that's not an issue we brought up. We strenuously objected. We moved the court to exclude Dr. Dixon. We believe the district court was in error to allow her. But even if her testimony stands, I think it's still irrelevant to the issues presented before the court.
So same-sex relationships have nothing to do with this case?
Same-sex relationships have nothing to do with this case, Justice Nelson.
As I understand it, you're contending that Ms. Kulstad does not have standing to inject herself into this relationship. I realize this isn't what we've got in this case, but what if the child, a child were to step forward, and would the child have standing to argue, Miss Maniaci, you are my mother, you've been a good mother, you've not abused me, but you have invited a third party into this relationship. I've bonded with Ms. Kulstad as a parent, and I think it's in my best interest that she be recognized as such.
I think, Justice Leapart, that the extent of the, and just, I see my time is up, may I answer the question?
Yes, please.
Thank you very much. I think the extent of the child's constitutional right, again, is clearly defined by this court in ARA. And I know you wrote a dissent on this point in the Girard case, looking at a little bit more of a expanded definition of perhaps the child's immediate family. I understand that point, but again, the child, I don't think, because the constitutional right at issue allows the parent to control the child, I don't think if the child were to combat the parent's interest, the child will win out necessarily there. The principle that the court would have to uphold is, child, the only fundamental right you have at issue is the right to be attached to your natural parent. You want to run off and go hang out with other people, you get the chance to do that when you're 16 or 18 or whatever the law may be.
So short of parental abuse, the child's best interests don't enter the picture?
That's exactly right. Because as this court stated in JNP, You're not going to get into the slippery slope of determining should a child be raised in an affluent household as into an impoverished household. Are we going to select a conventional relationship over a non-conventional relationship? That's the danger of crossing the bright line, as you get into that slippery slope and you start getting to the business of child rearing instead of just protecting children and making sure that fit natural parents and their children have every opportunity to develop the relationships they're entitled to develop.
Thank you, Mr. Nimitz.
I'll reserve the balance of my time for rebuttal. Thank you.
Ms. Griffin.
Thank you, Your Honors. It's a pleasure to be here today. May it please the Court, my name is Betsy Griffin, and I'd like to introduce my co-counsel, Kevin Lewis and Susan Ridgway. We represent Michelle Kulstad in this matter. There's been a couple of factual representations here that I would like to clear up before we go forward with the purely legal questions. There's a reference to Michelle Kulstad as being someone who was just in the home, that she was just under the same roof, that she was a roommate. Well, you would have to disregard all of the findings of fact in this thorough and complete district court decision to reach that conclusion here. Because a brief summary of the parenting facts show that in 2001, Michelle Kulstad and Barbara Maniaci, after living together for 5 years in a committed relationship where Michelle's funds were the primary means of support, brought the baby into their home. They intended, and I do think intent is important here, Your Honors, they intended to co-parent this child together, and even represented to the home study person for the adoption that they intended each to be a parent to this child. They both cared for the children on a day-to-day basis and operated as any two-parent family would. In 2003, a second child was brought into the home, and again, I do think the home studies are critical evidence here, Your Honors. A home study was done for the second adoption, and the home study shows that both Barbara and Michelle were intended as parents to this second child. The person who did the second home study, Dennis Radke, looked into the backgrounds, had each person fill out their backgrounds, knew that both of them would be considered parents. And when he gave his home study, he stated in his report that both parents organized their lives around their children's well-being, and it was, quote, an ideal family to adopt. Now, both children have viewed Michelle and Barbara as their parents. Dr. Cindy Miller, the court-appointed parenting expert, a court-appointed expert who performed the parental evaluation for the court, testified the children had a strong relationship and attachment to Michelle and confirmed that she is indeed a psychological parent to the children. Dr. Miller and Dr. Silverman, the children's therapist, confirmed that each child should have continued contact with Michelle and terminating, that's what we would be doing. We would be terminating Michelle's relationship with these children. Terminating that relationship would be detrimental to the children. It would have permanent, lasting effect on these children. These facts show that Michelle Kulstad was properly awarded a parental interest under Section 40-4-228.
Counsel,
wouldn't it be, under the argument that is against you, required then for your client to show some wrongdoing in allowing this in order to get your client parent custody rights? In other words, the argument that is presented in the cases are not misquoted by Ms. Maniaci's counsel, that there is this bright constitutional line. Just how do we get around that without finding that Ms. Maniaci did something wrong in allowing Ms. Kulstad in there?
Well, I think there are really two distinct ways and you don't really have to get around it. It's not a matter of getting around your prior precedent. We have a very different statute here that complies with troxel. It complies with the special weight that must be given to
I don't
a
think the
natural
argument
parent's right.
is made that the statute doesn't comply with troxel. The argument is made that it does not comply with our precedent, which is pretty strong, that we're not going to, we've created a bright line.
You have, Your Honor. I agree with that. The prior cases are all distinguished on law, facts, and the remedy asked for. Each one of those is distinguishable that way. And the reason I say it that way is that the statutes that were used in the prior cases were not this statute. And the test that was used by the court, the remaining test, what happened was, under the prior statutes, there was a standing issue and then a custody issue, right? And so what happened was a number of these people who wanted to have custody, and they weren't seeking a parental interest as such. These persons who wanted custody, guardianship, were effectively trying to terminate the parental rights of the natural parent. Number one, we're not trying to do that here. We're not seeking any kind of termination. And I think if you look at almost all of those cases, they were a termination. Secondly, that actual termination was to be based solely on the best interests of the child. That was, and this court said, indeed, best interests of the child cannot be used to terminate parental rights. And we have no complaint with that, with those holdings. And thirdly, the cases really show that there was a lot of confusion with respect to how to get standing in order to show a custodial or parental interest.
I can't help it. Do you argue that the court was confused?
No, that there was Justice Horner, there was a lot of confusion among the parties as to how to show standing. Not at all, Your Honor, not this court. No. And the reason is there wasn't a statute like the present one. It's really what we saw were people in the situation of our client looking to be able to establish a parental interest, and they couldn't under the existing statutes. And what happened with 44-228 was the legislature got it right. And that's our position, is that the legislature now got it right in properly balanced, considering what factors you need to consider, giving the deference to the natural parent, and how is the deference to the natural parent given here so that it is constitutional? I think we really have to look at that. And the court has to be very comfortable that you've met that troxel standard. We know under prior case law that the best interest of the child is not sufficient to gain a custodial interest. We know that. But this statute 44-228 does much more than that.
Well, counsel, that statute requires as a threshold matter that there be clear and convincing evidence that the natural parent has engaged in conduct that is contrary to the child-parent relationship.
Exactly.
What is the evidence in this case of the conduct contrary to the child-parent relationship?
Yes, Your Honor, that's an essential question here for compliance with the statute. And we have shown that there is substantial evidence in the record that Barbara acted contrary to her parent-child relationship in two ways. The first way is by bringing the children into the home and representing to the children that Michelle was their mother. Barbara necessarily acted contrary to her right as a natural parent in the child-parent relationship. Now, as argued by the appellant, the right to a parent includes the right to have this complete control and custody to the exclusions of others. And when a natural parent creates a parent-child relationship in another, and the children are led to believe that they can rely upon this co-parent, the natural parent is acting contrary to her right to be the sole decision maker for the children.
Counsel, in arguing that, oh, I'm sorry.
Let me just finish up, I'm sorry.
I'm sorry.
Well, let me understand your point. By bringing Kulstad into the relationship, Maniaci acted contrary to her, contrary to her parental interest, or contrary to the child-parent relationship, simply by bringing Kulstad into the relationship, or by pushing Kulstad out?
No, Your Honor, it's by bringing her in. And I really think that the de facto parenting cases are very instructive in this regard. Mason versus Dwinell, which is cited in our case, and VC versus MGB show that when you have this is actually a quote from VC that I think is very helpful. It says, "The cooperation of the legal parent is critical because it makes the adoptive parent a participant in the creation of a parent-child relationship in another, essentially ceding over to the third party a measure of parental authority and autonomy. If a legal parent wants to maintain that zone of privacy around being a parent, she cannot invite a third party to function also as a parent." And I think that is then, by this invitation, by this ceding of authority, she is in fact operating against or contrary to that right to have total control over the child.
And what's the second one?
Thank you, Your Honor. We also showed contrary to a child-parent relationship because we showed that Michelle Kulstad acted in loco parentis. And Barbara contends that in loco parentis means that the natural parent must be absent. It's not there. But there is no such limitation in the statute, and the term in loco parentis, as defined by this court, does not mean that and does not require that.
So isn't that really a different way of saying the same thing?
No, not really.
How does in loco parentis differ from what we talked about, Maniaci bringing Kulstad into the relationship and thereby ceding some parental rights?
Thank you, Your Honor. That's a very good question, because in loco parentis goes to the intent of the person who is trying to, with whom the children develop that relationship. In Peterson versus Cabbage, which is cited by Barbara in her initial brief, and which we have quoted in our brief, in loco parentis is defined by this court as, this is how in loco parentis is defined: a person intentionally assuming the status of a parent by accepting those responsibilities and obligations incidental to the parental relationship without the benefit of legal adoption. We have a case in this state, Your Honor, defining in loco parentis, and it involves intent. And I believe that that definition, if you apply it to this statute, absolutely shows that Ms. Kulstad has, or that Ms. Maniaci acted against her parental interest by allowing Ms. Kulstad to come in, share, have the intent, and really, she assumed the responsibilities and obligations of a parent. And really, it was their intent together to do so.
Counsel, let me go back to this argument that 42, 4, 211, and 228 are facially unconstitutional. Your opposing counsel argues in their opening brief, citing Troxel, for the statement that so long as a parent adequately cares for his or her children, i.e. is fit, there will normally be no reason for the state to inject itself into the private realm of the family to further question the ability of that parent to make the best decisions concerning the rearing of that parent's child. So how does 211 and 228 get around that sort of authority in Troxel?
Well, I think one of the things that Troxel absolutely recognized, Your Honor, is that the right to parent is not absolute. The right to parent is not absolute. If the right to parent were absolute, the children would be what? So much chattel, so much personal property. And so what Troxel requires is that the wishes of a fit parent be given special weight, and that there is a presumption that this parent acts in the best interests of the child. Section 40-4-228 gives this special weight to the natural parent and gives a presumption to the fit parent by imposing rigorous standards upon a petitioner to obtain a parental interest. These are rigorous standards, Your Honor. The petitioner for a parental interest must prove first, has a burden of clear and convincing evidence, which we certainly believe we have met. You recall that in Troxel, the statute was breathtakingly broad. Any person, for any reason, could petition for a visitation in that case.
Counsel, let me take you back to 228 for a minute.
Fine.
With regard to your evidence for the first conduct by Maniaci that was contrary to the child-parent relationship, in your view, is it critical to that analysis that Maniaci made this decision to have Kulstad brought in at the time the child was first brought to the house?
I think that's a very, very important point. I can't say that it's critical or makes or breaks the case, Your Honor, but that she did bring Michelle, or that Michelle, she was there and the child was brought into the home and that they co-parented from the beginning of the relationship, making, in effect, Michelle as much a mother to these children as Barbara is.
What were the age of the children when they brought into the home?
The age of the child, he was less than a year old. He was 1, and the daughter was was 1 as well. They were still babies, Your Honor.
Counsel, what about KEV? That seems to fly in the face of many cases that we have held that parental rights must be terminated before establishing a parental relationship in a third party, yet KEV seems to adopt the theory of de facto parentage or psychological parentage. Your co-counsel or opposing counsel says this is parentage case, not a custody case. How would you fit KEV into the scheme of things?
Well, I think KEV is actually very instructive because it actually shows how much equity this court does have with respect to determination of parental interests when you actually take into consideration the children's rights. And I think KEV is very much that kind of a case. I don't see KEV as an aberration. I see it as authority for the court to go forward with a de facto parenting if you chose not to follow constitutional statute 44228. KEV stands for authority that you can go forward with de facto parenting in weighing the actual equities of the relationship.
Well, counsel,
I'm sorry.
Go ahead. How do you account for the decisions after KEV that have reached a very contrary result, that tout repeatedly the fundamental right of parents?
Again, all these decisions are all on a case-by-case basis. They're all on looking at the facts. And in KEV, what was so remarkable there was that the natural mother said to this person, said to KEV, you know, you're the father. Here's the father. Would you sign the birth certificate? You're the father. And from the time that child was born, the mother represented to KEV that he was the father. She tried to get him to sign the birth certificate. He took on all the responsibilities as a father. In fact, the KEV is is instructive in the sense that it shows those critical facts that may be necessary to indeed not go into that bright line. And I don't necessarily agree that it's a bright line because Troxel, of course, doesn't require a bright line. The foremost reason Section 40-4-228 is constitutional is because it's a proper balancing of Barbara's right to parent with the constitutional rights of the children. To the extent parents have fundamental liberty interests in preserving stable parental relationships, so too do the children to their constitutional rights that must be taken into consideration in this equation of balancing the rights of all people in the family. Children are constitutionally protected under 40-4-228 by allowing parental bonds to be maintained. Children have a strong interest in maintaining the ties that connect them with adults who love and provide for them. And that interest is constitutionally enforceable, Your Honors. Article 2, Section 15 vests children with all constitutional rights of an adult, including the fundamental liberty interest attached to a stable parent-child relationship. And this right can only be infringed by law if the law enhances that constitutional right. Section 40-4-228 was designed to enhance the protection of children's constitutional rights, not limit them.
Well, Counsel, granting that the legislature, obviously through the precursors to the sections, is attempting to balance these rights, would it be your argument that this court could or should distinguish our prior cases, such as JNP, or should we just overrule these statutes, or the pronouncement that we've made about the bright line?
I don't think there's any reason to overrule them, Your Honor.
Okay.
I think they can be distinguished.
What's the distinguishing factor with this strong language that we've used in our case?
I think the distinguishing factor in the strong language that you used is the fact of termination versus co-parenting. In the past cases, I mean, if you ultimately go there, in the past cases you were looking at terminating a person's parental rights based solely on the best interests of the child. And here we're looking at a co-parenting situation. And if you're going to go down, even though if you're going to set aside that the statutes are different, if you're going to set aside that the facts are different in the sense that you don't, in those other cases, you don't have someone coming into the home and being represented to the children as a parent, not as an aunt or uncle, but this is a parent, this is your other parent. If those are distinguishing factors as well. But the nubbins is that those cases resulted in termination of parental rights, and that termination was based, what? Solely on the best interests
Counsel,
of the
how do
child.
we distinguish between termination versus co-parenting, as you phrase it?
Well, that's a very good question, Your Honor, and the way you distinguish that is you have to look at it from the children's perspective. You really have to look at the children's rights then at that point. Once you establish the parent-child relationship, it's the children's right at that point that begins to outweigh the natural parent's right to this kind of full custody and control.
And how do you counter your opposing counsel's argument that absent a Title 41 proceeding, those children's rights don't kick in?
I would strongly contest that, Your Honor. I don't think that's what the Montana Constitution is about. If the right to parent is virtually insurmountable, as claimed a number of times, or is absolute, as claimed by the appellant here, what does that mean to the children's rights? Does that mean they're virtually meaningless?
Well, counsel argues absent abuse, neglect, or whatever the standard was, that the parents' rights always trump.
And I would strongly suggest, Your Honor, that that's not what Article 2, Section 15 is about. I do think at a time short, when we actually have before the court a statute that adequately and properly balances the children's constitutional rights, You must take those into consideration in determining the scope and effect of the natural parent's rights.
Is it your contention in applying 228 that if I, as a single parent, decide that I want to round things out by bringing somebody else into the picture, so there's dual parenting, that is conduct contrary to the parent-child relationship?
Again, Your Honor, I think each one of these cases turns on its own facts. And that will be up to the district court at a certain point to decide whether or not the conduct actually is contrary to the parent-child relationship. We're certainly saying that in this instance, that when the natural parent holds out to the children, this person is your parent, and from the beginning, and I do think that may be a critical factor, from the inception of the parenting by both of them, that this person is your parent, she's your mother, you can rely upon her, she will provide for you, and that actually happens, that is actions contrary to the parent-child relationship.
Aren't you in effect saying that establishing a dual parenting situation is contrary to the child's best interest? That's contrary to the parent-child relationship?
For that, we're looking at which parent-child relationship we're looking at. And if you're looking at from the natural parent's point of view, co-parenting is contrary to their full custody and control. They're bringing in, they're ceding some of their authority.
They're sacrificing some of the exclusivity.
Exactly. Or what they are is sacrificing, ceding over. They're bringing that other person into this zone of privacy. And I think that's important, Your Honor.
Are you interpreting contrary as meaning inconsistent with?
Yes.
I guess that's what my question is, because contrary is used in the statute, and contrary sounds to me like something against the best interest of the children, but what I hear you saying is that if the parent brings another one in, it's inconsistent with the assertion of an exclusive relationship. Is that what you're arguing?
Well, I think that that's a very reasonable interpretation, Your Honor, and one of the things that really supports that is that that the legislature in subsection 4 says that acting in loco parentis is an example of acting contrary to the parent-child relationship.
Counsel, co-parenting wasn't an issue in ARA, but given the facts of that case, would it have been possible to allow parental rights with the stepfather and the natural father both under those circumstances?
Well, again, that's a separate set of facts, Your Honor, but I think the court may have been able, under that case, to have found that there was a co-parenting relationship, and that you'd have to go through the elements of the statute, right? You'd have to show a parent-child relationship, and you would have had to have shown that the natural father acted contrary to or inconsistently with the parent-child relationship. I don't recall the facts of ARA well enough to know whether or not the natural father there did act so inconsistent. He certainly didn't encourage or the stepfather to become a parent. Your Honors, the right to parent is not absolute, and appellants have failed to meet their heavy burden that Section 40-4228 is unconstitutional. Section 40-4228 establishes safeguards to protect the adoptive parent's rights by imposing 3 exacting requirements that must be met by clear and convincing evidence. Michelle is every bit as much a mother to these children as Barbara. Section 44-228 properly operates to protect the constitutional rights of the children to maintain their stable and loving parental bond with Michelle, which Barbara cannot unilaterally sever. We ask that the district court's excellent decision. It's thorough, it's complete, it's thoughtful. Be affirmed. Thank you.
Thank you. Rebuttal?
Counsel, I want to go back to Section 228 for a minute, and I want you to tell me why it's unconstitutional.
Justice Morris, Section 228 is unconstitutional, and there's several reasons. I think it's unconstitutional under Troxel, and I think it's also unconstitutional under the precedent of this court. One of the arguments I think this court is being asked to adopt is that somehow by adopting a high evidentiary burden of proof, which is all clear and convincing evidence is a burden of proof, that somehow compensates properly for fundamental constitutional rights. And I would respectfully submit that no measure of equity or an evidentiary burden of proof can ever adequately protect constitutional rights. When this court has said time after time after time, when we're dealing with a fit natural parent, the line that has to be crossed is abuse or neglect. And the legislature in 1999 enacts Section 228 and doesn't even remotely mention that bright line that this court now for decades has upheld. That's a serious constitutional problem because it allows, as has happened in this case, a set of facts or circumstances to come that allows a parenting interest to be established under 228 without even looking into the question of abuse or neglect. And so it's unconstitutional on multiple grounds, however you want to slice it. It would be one thing if suggested by one of the amici briefs, which I think is excellent, if 228 had this standard and it was there and all these parameters in looking into the fitness of the parent and whether or not the natural parent issue was fit. But that's not what 228 does. 228 says specifically, we don't care about the fitness of the parent, and the parent need not be found unfit. You can start parsing out parental rights to a third party based on the best interest of the child. And so I think clearly it's unconstitutional. There was a lot of argument by the appellee about intent and the intent of co-parenting. And I would respectfully submit that any evidence of intent is absolutely irrelevant for multiple reasons. It ignores all the precedent of this court. In every case, whether you're looking at Miller and you had the stepfather for 10 years or J&P where you had the
Well,
mother.
counsel, would it make any difference, assume for a minute that a single person wanted to adopt, and in order to impress the adoption authorities, that single person represented that he or she was going to have a partner to assist, so there'd be two parents. And the adoption aid, the home inspection person said, in light of that, we think that this is a good adoption, should be approved, as opposed to being on your own, you couldn't handle this kid, so I wouldn't recommend it. Does that factor into the equation?
Absolutely not, because before the adoption, Justice Morris, that person who is applying for the adoption is not a natural parent. The state is trying to make an assessment as to whether or not placing this child with this particular parent is a good thing. Once that placement is made, those rights as a natural parent kick in, and they've got a heck of a lot more rights than they did before they were adopted. And it denies...
That's kind of troubling. I mean, people can go to the state agencies, misrepresent the facts, have the state place the children, and then it's just like, so what? They got these kids by fraud and deceit? That's okay?
Well, I don't think that the state, Justice Nelson, ever necessarily places children in an adoptive situation just because of the presence or absence of certain people in the home. They assess the home situation to make sure that when they bring the child to this home, the child's not going to be subjected to harm or abuse. It's a prophylactic measure. You know, nobody guarantees and has to guarantee that their home environment will remain the same all the time. And this is the problem with intent, this intent argument, is it ignores the facts of life. The facts of life that things happen and change. It ignores the idea that a fit natural parent can change their minds. I'm a parent, I think there's probably a lot of parents on this panel right here, and you have the right to have your children develop a relationship with somebody and at some point in later time determine this relationship is not a good idea and change your mind. That's how we have Troxel. Look at the situation. It's a relationship with grandparents, for goodness sakes, and the parents said, this is not the route we want to go. And the argument that you're being asked to accept by the appellee is that there's somehow this magical point of no return, that once you cross a line and you enter a situation that you, as a fit natural parent, are not entitled to control which direction your children's future goes.
Well, Counsel, I agree with you. I think things do change, and it seems to me over the years, society has changed, and now we have blended families and gay families and straight families and boyfriend families and all sorts of different family situations. A lot of these driven by economic times, social mores, the whole works. Doesn't the law have to change to accommodate those or not?
Well, that's up to the people of Montana and the legislature. If the people of Montana want to change, for example, the definition of marriage and the definition of who can become a natural parent, or the legislature wants to change the adoption statute.
We're not talking about marriage here. We're talking about a custody situation, so let's stick with that.
I bring it up only in the context, Justice Nelson, of the parameters that are defined in Montana law of how you become a natural parent. And that's it. And there are clear parameters in Montana law of how you become a natural parent and who can become a natural parent. And those can be changed, and it's the prerogative of the people or the legislature to do. Until that is, we're stuck with what we've got. And we've got a very limited window in Montana of how you become a natural parent. And once that title is bestowed upon you, you get your constitutional rights, you're put up on a pedestal. And this court has jealously guarded over decades
Counsel,
those rights.
aren't you in effect arguing that the rights of parents are in fact absolute? In your argument that you have the right to change your mind? In other words, I can see where a parent should have the right to change their mind about the relationship that a child should be allowed to continue with, especially a young child such as we have here. But doesn't your argument then assume that the government can never inquire behind the motives or the intent in changing your mind? In other words, it's irrelevant as to whether or not a person who has parental rights changes their mind because they've decided that they don't like this other person and they totally disregard the child. That a parent can do that.
Well, and I
think a parent has a just an absolute right to decide what this child is, who they're going to live with for any reason or no reason at all, or a bad reason.
Justice Warner, my argument does assume that, and that's because it's constitutionally required. No child has a fundamental right to a perfect parent. If that was the standard, then we would all be failing as parents.
But counsel, certainly I agree with you about no perfect parent, but under your absolute argument, how does Title 41 exist?
I'm sorry, I didn't understand.
I said, under your argument about the extent of the parental rights, how does Title 41 meet the standard?
It meets the standard that is the bright line that's been drawn by this court saying the fundamental rights of the fit natural parent are absolute so long as they're not crossing the line of harm, abuse, neglect, abandonment, etc. All the elements under Title 41. And it's an appropriate bright line to draw because once you cross that line, you start getting into determining which decisions are best for the child.
But the statements by this court are even broader than that. You know, that the parental right is absolute, or is a fundamental right. And I'm not certain under those statements, Title 41 itself would be constitutional.
Well, I'm not saying it's absolute under all respects. I mean, if a parent starts abusing a child, that changes the tables dramatically. And the state is entitled to intervene.
But we have all sorts of statutes short of abuse where the state is directing the parents on how to raise their children. You know, you have to go compulsory school attendance. How do we enforce it? What parents, I don't want my kid, I mean, I can homeschool in Montana, but I'm not going to educate. What if they said, I don't want them educated? We can say, can enforce that.
So, well, I mean, parents do have a right of homeschooling and to control certain things with regard to that. But here we're talking about relationships specifically. And I'm not trying to avoid your question, Justice Morris, but the precedent we're talking about here and that I'm relying on making this argument has to do with relationships and not necessarily some of the other aspects of that, although I do understand your question. I'm not prepared to answer questions on schooling per se, but in terms of relationships, who you're spending your, may I finish?
Sure, and I have one follow-up question.
Okay.
Go ahead.
I was going to say, in terms of relationships and who children bond with, the parents are entitled to make those decisions, absolutely. And this court, the line of cases is unquestionable in that regard.
So before you finish, would you address this tension or distinction between a termination and a co-parenting relationship that opposing counsel discussed? Are the two mutually exclusive?
I'll be candid in telling you I don't understand the distinction. Because in every case that this court has dealt with, JMP, Miller, KM, Doney, you name it, you have an intentional and or express co-parenting situation. JMP is an easy example. The mom takes the child to her great aunt and uncle. There's an understanding that they're going to be the parents and they're going to be engaging in this parenting adventure together. The same thing in Miller when the mom brought in the stepdad. And that goes into the intent argument that I was rebutting earlier. There's an intent, there's a co-parenting situation in all of these cases. But this court has repeatedly said, you want to co-parent? You want to live with the grandparents? It doesn't matter until you, as the fit natural parent, have your rights terminated through a Title 41 proceeding or start abusing and neglecting your kids. It doesn't matter. There's really, and in the jurisprudence of this court, there's only one real situation where the mom did, in fact, lose or had a suspension. She didn't lose. She had a suspension of her parental rights, and that's the JC case. And those were very extreme circumstances where the mom came before the court under oath, acknowledged that she couldn't care for her kids, signed another thing under oath, and submitted with the court saying she wasn't a fit parent, and had a bad IQ, and there was a lot of circumstances involved in there. But that was a very extreme example, and that's the only one. Other than that, the right of the fit natural parent has controlled under circumstances that the facts of this case fall clearly within.
Thank you, Counsel.
Thank you very much to the court for the time.
Thank you all. This matter is submitted.
I'm going